All right, everybody, welcome back to the Bald Guys of Bankruptcy. Rich, how's it going?
We're back.
We're back.
It's good to be back, man. I miss you. This is fun.
I miss this too, so this is good. All right, so look, a number of weeks ago, I actually did a short on the Oheka Castle bankruptcy filing. Admittedly, it wasn't too in-depth. I know today we're going to be discussing it. But before I guess we get into the actual filing, could you give us some background on what happened before they filed or just overall with Oheka Castle situation?
Oheka Castle is like this amazing piece of property on the Gold Coast of Long Island. You know, it's literally a castle.
For those of you not from Long Island, I think you might also recognize Oheka Castle from HBO's Succession, Gossip Girl, and a Taylor Swift video.
It's got a golf course, it's a catering facility, it's a wedding hall. You know, it's very high end. So you would think, oh, you know, swimming in money, there are no issues there. But that's not true. They were in foreclosure for many years. And it eventually led to a judgment of foreclosure being entered, and there was a sale scheduled, and the property was going to be sold at auction. And that was what led to the bankruptcy filing this past summer. They were trying to stop that foreclosure sale from happening.
Okay, so the property was in foreclosure.
Right.
What's the name of the company that owned the property?
It's Con Property Owner. That's the name of the debtor.
Was that a single asset company? Like, did they only own Oheka Castle?
This is considered a single asset real estate case, right? What that means is that's a bankruptcy involving a single property or project other than residential property, right? So it's not residential property, and it has to have fewer than 4 units. And it has to generate substantially all of the income, okay? So that's what this is. It can't be a farm, right? And it can't have any other like significant or substantial business being generated there.
Well, what's interesting is when you normally think of a single asset, we normally hear the term LLC, but a single asset company, you normally think of like a single small residential property. You don't think of them owning a castle. So they have financial trouble. Presumably people aren't renting the castle enough or there's mismanagement somewhere. So what happens?
Yeah, I mean, it could be a bunch of factors that led to the filing. Mismanagement, like you said, recession, economic struggles, not as many people getting married, whatever it is, there were struggles there. There was a default that went back, I think, about 10 years. So they filed bankruptcy. And what they're trying to do now, and before we can get into that, we might want to take a step back and just look at the debtor's claims. Okay, so that what they did is they filed a motion for a 2004 examination. And what that means is they're asking the court to issue an order allowing them to issue subpoenas to an entity, right? In this case, the entity is called FBE Limited. And they want that company to produce documents and then be available for oral examination under oath.
Why would they want that?
Prior to the bankruptcy filing and during the foreclosure action, the debtor was in negotiations with an adjacent country club to purchase about 10 acres of land. And their intent was to build condos there and basically expand their property and generate more income. They had what they're calling a country club option, so an exercisable option to eventually build on the land. They were paying $1 million a year for 6 years to maintain that option. They were approached by this company, FBE Limited, to help them take basically the next step in constructing the condos on the property. What wound up happening was FBE, according to the debtor, so these are the debtor's claims, FBE wound up purchasing the option and then flipping it to the secured creditor. So the entity that's foreclosing on the debtor, this FBE purchased that option and flipped it to them. All right. Seems like a conflict, at least that's what the debtor's claiming. And they're claiming, hey, we gave FBE some confidential and proprietary information with respect to our zoning, any development approvals that we had, and that they took that to their advantage, purchased the option, and then flipped it to secured creditor, right? The entity that's foreclosing on it.
Is the argument, right? Because I'm imagining if this is occurring within the bankruptcy, right? Is it occurring within the bankruptcy?
Well, this all happened prior to the bankruptcy. What the debtor's trying to do now is they want FBE to produce a whole bunch of documents and then come and testify under oath so they can question them to see exactly what went on with that whole transaction.
Is the argument that they would not have been forced to file a bankruptcy if this had not happened?
They're not saying that, but I think what they're trying to say is, hey, we had this opportunity to potentially bring in more money and to expand, and then it would have actually benefited our creditors because we would have been generating more money.
Because I would see it as two paths. One, their argument could be, had this not occurred, we would have been able to build, create condos, generate additional revenue, and that would have kept us out of bankruptcy. So the other option would be that the lawsuit itself has value, and they would say, let's see how this lawsuit plays out because this could generate money or in a settlement or decision that money could then be used for our creditors to repay them to some extent.
Possibly, if this results in them having a viable cause of action that can lead to some sort of monetary gain, then certainly. They're not there yet. They're not making such claims yet. They're really just at this point with the 2004 exam, they're in a fact-finding mission to see if they do have a claim.
Where that leaves me, though, is why would that subpoena be relevant within a bankruptcy filing? Like, I get why they want to subpoena them. That makes sense. But couldn't the court say, you have a cause of action against this company, go do that?
Yeah, certainly. I mean, that could be the result. As of this recording, the motion hasn't been heard yet. So we'll see what the court says. They can certainly say, no, this is irrelevant. I suspect that they won't. They might let them see if there's anything there. But as of now, we just don't know what the court is going to rule.
The argument that would follow could be the secured creditor basically forced us into this bankruptcy by doing this.
Well, I think the next step, right, I think the next step might be, and again, this hasn't happened yet, but I would imagine, I can envision the debtor filing another motion for a 2004 exam against a secured creditor.
Right.
I'm sure they'll want to subpoena some of their records and see what their involvement was, not only with that transaction, but possibly how they came about purchasing the note, because they purchased the note, the secured creditor, in 2021. They weren't the original lender, which is common, but I can see them wanting to get some information as to how that transaction came about.
Let's just switch gears here now to like the nuts and bolts of the bankruptcy. Like what's going on, what's happened?
Well, the next step is going to be the hearing on this debtor's request for a 2004 exam. There was an objection filed. Interestingly enough, it wasn't by FBE Limited. That company didn't oppose it. The secured creditor filed a limited objection, basically saying whatever, subpoena your documents, but they are opposing some of the suggestive language that the debtor put in their motion, basically saying secured creditor came about purchasing this option in an improper way, that there was some illegality there. And secured creditor seems like just wanted to clarify the record and say, they're saying, debtor, that's great that you said that, but it's not true. You didn't provide a contract that you had any exclusivity with FBE, right? So there's really nothing illegal that happened here. You didn't prove anything. Mm-hmm. So it was a limited objection. They just wanted to clear the air there.
Is the bankruptcy itself on pause while we're waiting for this hearing on the subpoenas?
It's not on pause. The debtor still has deadlines to file a Chapter 11 plan. He has to do that within 120 days. We mentioned earlier that this was a single asset real estate case, right? And that affords the creditor some protection here. If the debtor doesn't file a plan, this is according to 362D3 for you nerds out there. If the debtor doesn't file a plan within 90 days, a feasible plan, or doesn't start paying interest payments to the creditor gets relief from stay. The court shall enter the order. So the creditor could be out of here within 90 days of the filing. So the filing was 7/31, July 31st. So we're coming up on it. October 31st will be 90 days. So again, if the debtor doesn't file a feasible plan or begin making interest payments, the creditor is out of this case and can foreclose.
And when you say the court shall, is that upon request for relief from the
there has to be a motion filed. It has to be a hearing.
Okay, so we would think 90 days, then you file a motion, maybe 30 days later, you could actually get relief?
Yeah, I mean, if there's no plan filed and no interest payments being made, according to the records, the debtor hasn't made payments in many, many years. So,
is there a possibility that this was filed just to issue that 2004 request for the subpoena?
I think that probably played into it, but certainly the main reason was just to stop the foreclosure sale.
Stop it.
Yeah, it was about to happen.
I know it's hard to speculate, but do you feel like this is a viable bankruptcy that's going to play its way through? Or do you feel like it was maybe filed to stop the sale and maybe get a subpoena and try to just drum something up?
Tough to say. They have good counsel, and everything has been filed properly, and certainly there's a chance of success here. It seems to me like the debtor still needs to pursue this plan to expand and build condos to have enough money to generate anything. So I think it's a long shot, but it's certainly possible.
If their way out of bankruptcy is to buy property, because that was an option to buy property and then build and then rent, that's not a year-long process. That's a serious process.
No.
And not to mention, it sounds like someone else owns the option now, forgetting their relationship.
Right.
You got to defeat that, then get the property, have enough money to build. It's a complicated path they're going down.
So what's next is we'll see how the court rules on the debtor's 2004 motion. I would look for possibly another motion filed by the debtor in this case to perhaps subpoena the secured creditor. And then we'll go from there. The court will, if granted, will issue a scheduling order, and we'll monitor the case, and I'm sure we'll provide an update at some point.
Okay, it's interesting, Rich. I really appreciate it.
Bald guys, bald guys, bald guys of bankruptcy. Bald guys, bald guys, bald guys of bankruptcy.